Hey guys, welcome back to today's video. Today, we're looking at two sovereign citizens in court, with one being a follow-up to someone I've covered before. The second case has an ending you definitely won't want to miss. But first, we're starting with a clearly unhinged individual named Zoe Galloway, who has a jury trial coming up. So, let's get started.
Let's see, Mr. Contreras appears on behalf of the prosecution. I am a senior judge, Ms. Galloway. Judge Meyer is in a 3-day trial, so I'm just helping her out with her dockets, and she was unavailable today. We didn't want to continue these matters. And give me 1 second here just to find your file. So I see that the case is 101 days old. You last appeared in court on December 11th. And looks like you did not want to fill out an application for the services of the public defender's office, and you did not want to speak to the prosecution. Is that right?
Well, first of all, I'm here on special appearance.
I don't know what that means.
Okay.
You're not here on a special appearance. You're actually here on a summons issued by.
I am here on special appearance. Okay. And by the way, I also filed a notice of presentment. Unfortunately, it was sitting in the mailbox for about a week.
I don't know what that means.
Okay. Well, it's a conditional acceptance offer.
I don't know what that means.
Okay. Well, the prosecuting party has not yet established mens rea, actus rea, corpus delicti, or provided any proof of an injured party.
That's why we have trials.
Okay. Well, they have to do that in order to establish subject matter jurisdiction.
Okay.
So
sounds like we're going to set this case for trial today.
Okay. Well, I will only conditionally accept if the prosecuting party develops subject matter jurisdiction. It is officially being questioned, so they have to develop that, and they have to, present actus rea and mens rea.
Yeah, I heard what you said. My question to you is, how do you wish to plead, guilty or not guilty? We're setting this case for trial today.
Okay, so I have a conditional acceptance.
I don't know what that means. All I'm asking you is, how do you wish to plead? If you choose not to answer my question, I'll just enter a not guilty plea on your behalf.
Okay, so
how do you wish to plead?
I will only conditionally accept under the conditions that the prosecuting party within the next 14 days is able to establish all of these
I'm
elements.
denying your request, and I'll enter a not guilty plea on your behalf since you're refusing to do so on your own behalf. And so this is going to be a 1-day trial. The trial will commence on
March 25th at 8 a.m.
March 25th at 8 o'clock in the morning.
So I want to point out that I am
I'm not finished talking.
I am the only injured party.
I'm so sorry, but when I talk, you don't. When you talk, I don't. The pretrial readiness conference will be on
19th at 2.
Okay.
Are you a neutral judge in this matter?
Am I what?
A neutral judge in this matter? Or are you
a neutral judge?
Yes.
I don't know what that means.
You know what neutral means?
I don't know what you're asking.
Are you on the prosecutor's side, or are you neutral in this matter?
I am not a prosecutor. I'm not a defense attorney. I'm a senior district court judge assigned.
Are you on the prosecutor's side, or are you neutral in this matter?
I just answered your question.
You did not answer my question.
Well, if you're not satisfied, I'm sorry. The motions hearing will be on.
Sorry, I need to change that. Pretrial readiness is March 10th at 2:30.
March 10th at 2:30. The motions hearing will be on
February 27th
at 11.
So be aware that I placed a bond on this matter and a notice of presentment.
Okay, thank you. And so let me just recap what we're doing. We are having a jury trial. Right now, you are presumed innocent, and it's the prosecutor who has to prove actus reus and mens rea and all of the elements for the crime that you're charged with to a jury of 6 unanimously beyond a reasonable doubt. That trial will be conducted on March 10th at 2:30 in the afternoon. Excuse me. That trial will be on March 25th, beginning at 8 o'clock. We're going to have a pretrial readiness conference to make sure the parties don't have any last-minute issues. That'll be on March 10th at 2:30. I'm setting a hearing on February 27th at 11 o'clock for any motions that need to be resolved. I'm going to mail to you a pretrial discovery order. And essentially what it says is that the parties need to endorse witnesses within 30 days of today's date. Any motions need to be filed within 30 days of today's date. Any expert witnesses need to be endorsed no later than 30 days prior to the pretrial readiness conference. And again, you'll be receiving a copy of that. Jose, I'll need to send you this.
So the prosecutor needs to be aware they have 14 days to respond to this notice of presentment.
They do not. I'm the one who sets those
Okay.
deadlines, and they do not have to do what you say.
Ubius ibi remedium.
And so
So
I see that you're currently on a summons, and your summons is continued until the next court date. If you don't show up, a warrant will be issued. Have a nice day. Thank you, Ms. Galloway.
Well, that definitely didn't go the way she expected. And I love how the judge clearly told her that the prosecution didn't have to follow her demands and that he was the one in control. Normally, I'd be hoping for the same judge again, but luckily, the original judge is just as no-nonsense as before, which brings us to the next hearing.
Are we ready to call Ms. Galloway's case?
Yes, Your Honor.
Okay, the court calls People versus Zoe Galloway, 25T3675. Ms. Galloway appears and is coming forward. Mr. Lemieux appears on behalf of the people. Good afternoon, Ms. Galloway. The case is set.
Your Honor, I'm
Um,
Zoe G. Kendrika Galloway, and I repent of all my sins, and I'm here on special appearance, not general appearance, and I reserve all rights with explicit reservation. Your Honor, does the court's record reflect that this court is in possession of my valuable negotiable instruments, being acceptances?
So,
And then-
Ms. Galloway, first of all, I'm going to ask that you hold on for a moment. Okay, I need to make a record. So, Mr. Lemieux appears on behalf of the people. We are set today for trial readiness. The case is scheduled for trial on March 25th at 8 o'clock. The 3 remaining counts after the court received proof of insurance and dismissed that count are speeding 10 to 19 miles over the speed limit, driving without a license, and driving with fictitious plates. Mr. Lemieux, are the people announcing ready for trial?
People already are. Honor.
Okay. And Mr. Lemieux, have you extended an offer in this case?
We have.
Okay. And just for the record, can you just put that on the record, please?
Your Honor, how is it that this court can retain custody of all the discharge instruments, being my negotiable acceptances, yet still attach charges to my physical body when discharge has already occurred?
So,
Does-
Ms. Galloway, I don't know what any of that means. I know that you filed a number of motions
So-
with the court that make no sense to the court, and I don't know what any of those
Your
things
Honor, how is
mean.
it that you can draw draft instruments on an account that you control, that you have made the prosecutor and junior security interest and accommodation party on, that you
Okay, so
send
Ms.
those
Galloway,
to
I
me?
asked Mr.
and that you
Lemieux
do
a
not
question,
understand
and I'm
what they
waiting
are?
for him to respond to the court, so I'm going to ask that you stop interrupting. Mr. Lemieux, if you could just make a record for the court as to what the offer is that's been extended in this case, so it's clear to Ms. Galloway what the offer was
I guess
or is.
I'm looking at the notes, and it looks like when we tried to convey offers previously, the kind of same thing that happened now just happened again. So I'll just convey the offer here then on the record to plead guilty to speeding 5 to 9 miles over the speed limit. with a $10
Excuse me,
fine.
but does the record reflect I do not plead guilty, but that I plead equity?
Honestly, you should be pleading insanity, because pleading equity isn't even a real thing, and insanity might be the only way a sovereign citizen doesn't lose in court. I'm pretty sure your so-called assent is just nonsense, but regardless of all that, the only way you're getting any closure here is by either pleading guilty or going to trial.
Okay, thank you, Ms. Galloway. Please stop interrupting. Everyone gets a chance to talk. Mr. Lemieux, the offer is plead to speeding 5 to 9 miles.
$7 fine, and then plead guilty to expired plates, Your Honor.
Okay. So it sounds as though that's the offer that the people have extended. It's pretty clear, Ms. Galloway, that you're not interested in that. We are set for
Actually, excuse me,
trial.
but does the court's record reflect that I have accepted all presentments and offers of the court, the clerk, and the prosecutor, and I have returned them for discharge of this matter? How is it that this court can retain custody of all those acceptances yet not recognize that discharge has already occurred?
So, Ms. Galloway, the only way that you are entering a plea in this case is if it happens on the record in front of the court.
Does the record
So-
reflect that I plead equity today?
So there's no such thing as pleading equity in this case based on the allegations. If
So
you want to
you're-
accept the DA's offer, you're certainly welcome to do so.
Does the record reflect
would
I
be
have accepted
happy-
and returned all presentments and offers of the prosecutor, the court, and the clerk? And
So Ms.
it-
Galloway, the DA's office has
Mhm.
not filed any plea paperwork with the court that you've signed and returned to the court. I've never been provided any proposed agreement between the parties in this case.
Does
So
the
if
record
you
reflect that
want
I
to
have
accept-
sent my plea of equity to the court, the clerk, and the prosecutor in this matter?
So
and
Ms.
that
Galloway,
do
I
indeed
have
plead
received
equity?
all of the things that you have filed in this case. They're all reflected in the court file.
Does the court record
Again,
that I did not file anything? And Your Honor, I accept your dishonor in this matter. Does the
Okay.
record reflect I plead equity?
Okay,
And
so
how
Ms.
is it that
Galloway,
you do not
we're set
understand
for
the-
trial then on March 25th at 8 o'clock. I'm not going to go back and forth
Okay.
with you. So clearly you're not accepting the DA's offer, which is absolutely your right. We're scheduled for jury trial on
Does the
March
record reflect I
25th
do
at
accept
8
and
o'clock.
return the DA's offer?
So the DA just explained to the court today that today is the first time that they've ever extended an offer that you have been able to listen to. If you want to accept the DA's offer, I'm happy to pass the case, have you read through some paperwork and recall the case, but plea paperwork has never been filed with this court.
Does the record reflect I hereby accept and return the prosecutor's offer for full settlement and closure of this matter?
So are you wanting to accept the DA's offer to plead guilty to speeding 5 to 9 miles over the speed limit and driving with expired plates?
Does the record reflect that I accept through assent, not consent, and that I have accepted and returned all offers? of
So Ms.
presentments
Galloway,
of the
your
co-
options,
the
if you
court, the
want to
clerk, and the
accept,
prosecutor.
your options, if you want to accept the DA's offer, are to plead guilty or no contest
And what's the other option?
to proceed to trial on March 25th.
And does the record reflect that I plead equity? And if you do not, Your Honor, if you do not understand equity pleading, surely you have a duty and an obligation to recuse yourself and place me before a judge who does understand equity pleading so that I can settle and close this matter today. Does the record reflect that I have honored your court by accepting and returning all presentments and offers? And that this matter has been fully discharged already?
So Ms. Galloway, the matter has not been fully discharged. As I've explained
I
repeatedly.
accept your dishonor.
The DA has extended an offer today. Do you want to accept the DA's offer today?
Does the court's record reflect that I accept by assent, not consent, and I return it in personam to the prosecutor and the judge and the clerk for full settlement and closure of this matter?
All right, that wraps up this case. Looks like we'll be seeing her again in about a week and a half when her trial begins. Next, we've got a follow-up on a sovereign citizen we've covered before, Lawn Royale. The last time we saw her, she was invoking the Fifth and using her right to remain silent while still filling the record with sovereign citizen nonsense. Unfortunately, there's no video from this trial because the judge said it wouldn't be possible without showing the jury on camera. However, we do have the audio, and I've condensed it into 3 parts. First, we'll go over the highlights from the cross-examination of the first witness. Second, we'll cover the cross-examination of the second witness. And finally, we'll get to her sentencing, where she basically turns her PR bond while awaiting sentencing into actual jail time.
Ms. Galloway, would you like to accept the DA's offer today?
Does the record reflect I already answered that question and then I accept by assent, not consent, and I attach it to the prosecutor in personam for full settlement and closure today?
Okay, so the court's going to take that as a no. We're set for
Excuse me, does the
trial
record
on
reflect
March
that the judge is
25th at 8
obfuscating the record
o'clock.
by putting a false words into the mouth of the defendant and denying the defendant due process rights?
Ms. Galloway, I'm not denying you any due process rights. We're set for trial. Your options are to accept the DA's offer or to proceed to trial. I'm not going to keep going in circles with you.
Okay,
So, Mr.
I
Lemieux, I'm
accept
gonna
and return
impose
trial to
deadlines.
you in personam for full settlement and closure. Judge, I accept your dishonor in this matter for retaining custody of the negotiable instruments, yet not recognizing that discharge has already occurred. Judge, isn't it true that in accordance with the exemption of the constitutional clause, the acceptance is the only means of payment? and that negotiable instruments must be accepted on the face of their value, and therefore
Galloway,
full
this is
settlement
not a
has been.
civil case. This is not a money case involving two parties in a contract. This is a criminal case where there are traffic offenses that have been alleged against you. So again, as I've indicated, if you would like to accept the DA's offer, you are absolutely free to do so. But your options then are to either plead guilty to the two charges as the people have indicated, or for you to plead no contest.
Does the record reflect I plead equity and I return all presentments and all offers to the prosecutor? And Your Honor, I know you and I both know that while this purports to be a criminal matter, it is actually commercial in nature, right? Otherwise, why is there a QSIP number attached to the bonds on this case? And Your Honor, do you have a financial interest in this matter? Isn't it true that this court has already packaged several bonds and attached and handed them off to an indentured trustee to be prepared for securitization on the open market?
Ms. Galloway, you were issued a summons in this case. You've never posted a bond, and this court has absolutely zero financial interest in this case. Mr. Lemieux, the court is going to give the people until March 20th at noon to file your proposed instructions, good faith witness list, and good faith exhibit list. The court will then give Ms. Galloway until March 24th at noon to file any proposed changes to the people's instructions, her good faith witness list, as well as her good faith exhibit list. Ms. Galloway, we're set for trial on March 25th at 8 o'clock. So we'll begin with jury selection. There'll be probably about 30 members of the public here. The parties will both have an opportunity to ask questions of the potential jurors, and then ultimately we'll select a jury. The parties will have the opportunity to select a jury of 6. We'll then proceed to opening statements. The people will then have an opportunity to present any of their evidence. You will have the opportunity to ask questions of any of their witnesses. You'll then have the opportunity to testify yourself, present any witnesses or evidence that you have, and then both sides will have an opportunity to make a closing statement. Do you have any questions generally about how the trial will proceed, or any basic trial procedure questions that I can answer for you?
Does the record reflect that I employ my equitable right of rescission and rescission anything that I may have unknowingly acquiesced to in this matter, and that I do indeed plead equity, and that I accept your dishonor and attach trial to you in personam for full settlement and closure of this matter?
Again, Ms. Galloway, I don't know what any of that means. None of those words are criminal terms that are in the statutes or the Constitution of the Colorado Constitution or the federal Constitution. There's no option to plead equity. I don't know what you're referring to. I've explained to you repeatedly what your options are. So at this point, I've imposed deadlines for trial.
Does the record
We'll see
reflect
you
I
back
plead
here
equity and the
on
judge
March
is obfuscating the
25th
record by
at
entering
8
a false plea on behalf of that defendant? And your judge, if you do not understand the negotiable instruments laws of the state of Colorado, the United States of America, and the accounting on this matter, surely you have a duty to recuse yourself of this matter so that I can be put before a judge who does understand equity, so that I can settle and close this matter and bring full honor to your court.
So, Ms. Galloway, as I've referred to you repeatedly, as I've explained repeatedly, this is not a civil case. There is no money. There's no negotiable contracts.
Your Honor, are you
can-
trying to overturn
you
hundreds
can
of years of an
file
equity
whatever you would like with
jurisprudence?
the court. The court is following the procedures required of me. So we'll see you back here on March 25th at 8 o'clock for jury trial. Thank you.
I
The
accept your
court is in
dishonor and I return
recess
it back
this
to you in
case.
personam for full settlement and
Ms.
closure.
Galloway, the court's in recess on this case. We'll see you for trial on March 25th at 8 o'clock. Thank you.
Well, she's clearly not the brightest, and I still don't understand why sovereign citizens think it's so important to ask judges or police officers to recite their oath of office on demand. It's really not the gotcha moment they believe it is. Anyway, now we move on to the second and final witness, who just so happens to be married to the
Office.
first.
I did.
Can you describe that oath to us?
I do not recall the oath word by word from when I started through the sheriff's office.
Do you realize there's a difference between a driver and a traveler?
I don't understand the question.
Do you know what a driver is?
Yes.
Do you know what a traveler is?
Yes.
So you do understand the question. Do you know the difference?
I believe they're the same. Driving and traveling is the same.
You're not. That's how I wound up with 8 cops around me, because you didn't have a ticket book and neither did your husband.
I don't know if that's why.
That is why.
Ms. Real, I'm going to interrupt you real quickly. You're fine. You're doing fine asking questions, but there shouldn't be any sort of commentary after that question. You'll have an opportunity later.
Was your husband in uniform?
Yes.
You're sure of that?
Yes, he was wearing a polo shirt that was provided by the Conejo County Sheriff's Office that did indicate that we were with the Sheriff's Office.
Okay, because when he pulled me over, he was in a pair of shorts, shoes. Okay, didn't have a uniform on.
Ms. Real, is that a question or is that just commentary? I've already warned you once, no commentary. Ask a question, perfectly fine.
So then you weren't patrolling the carnival.
Is that a question, Ms. Real?
Were you patrolling the carnival?
Yes.
Then you would have known what I was doing that day.
Ms. Real, for the third time, right? I'm going to tell you, if you have a question, ask a question, not commentary.
You said you followed him,
Yes.
so then you knew where he was.
Ms. Real, this is the last warning you're going to get. Okay? Look at me, Ms. Real. No more commentary. You may not like the answer to the question, but you've asked the question, she's answered the question. The jury can then decide the credibility of the answer. But you don't get to comment at this stage. You get to ask questions at this stage.
Can I ask why you cannot say your oath of office?
I don't remember it word by word, and I don't want to say something that isn't fully true.
Is this part of your duty? Are you required to know it?
Ms. Real, you don't need to object, Mr. Barnett. Ms. Real, you've asked that question and you've asked it multiple times. I've been very lenient with you, very lenient on your questions, okay? She's answered it. Move on to your next subject.
I have no further questions.
All right.
When you say commerce, are you talking about something like working at a carnival and selling food to people, like you mentioned earlier? Because if that's the case, then you've basically just ruined your own argument. And even by your own logic, you'd still need a driver's license to operate a vehicle, which you didn't have. So now, we're going to play her very short closing argument and then go straight to the jury's verdict.
Mr. Campos, are you an agent for the state?
I am a deputy for the Conejo County Sheriff's Office.
When are you required to turn your lights on, like when you're pulling somebody over?
I did not have lights, so when I flagged you down, I asked you to pull over. So I did not have lights on the ATV.
Are you aware that the only time you are supposed to use your lights is when there is an emergency? Was there an emergency that day?
There was a traffic contact that I needed to make because
Was it an emergency?
it could have been with the way the driving was, the driving that I observed.
Are you aware that the state or an agent for the state cannot be a witness to the case that they are a party to?
I was the investigating officer, so I would be a witness to the case.
Were you aware that I was a vendor at the carnival that day?
From your conversation with Chief Rendon about your vendor's license and needing a vendor's license and stuff, I assumed you were selling food and stuff, so.
Yes, and I did have a food handler's permit. Is a traveler required to have a driver's license?
No, a traveler is not required to have a driver's license, but an operator of a motor vehicle is required to have a driver's license. A traveler could be anybody going from one point to another, either by walking, riding a bus, riding a bike. That's a traveler.
Is a driver considered someone working in commerce?
No. Driver is anybody who is operating a motor vehicle, in control of that motor vehicle. They don't even have to be moving the vehicle. As long as they're in control of the vehicle, sitting in the vehicle with the keys in the vehicle, then that's still a driver of the vehicle.
Is a traveler considered someone who works for commerce?
When you say commerce, do you mean like someone who's working at a carnival selling food to other people as you stated that you were? Because if so, then you have just destroyed your own argument. And even by your own delusional standards, you need a driver's license to drive a car, which you didn't have. So, now we're going to play her very brief closing argument and go directly to the jury's verdict.
Ms. Real, would you like to provide any closing argument?
Yes, I would.
Okay.
I would just like the jury to know that there are things that are false and deemed to be made true. Anyway, I just want to say, do not be deceived. You know, because there are things that are false and they're deemed to be made true. And I feel this is what's going on in this case. I have nothing further for you.
All right, Ms. Real, let me explain a little bit about what happens now. Again, you were found not guilty of count 3, which is the most serious of charges in this case, is an unclassified misdemeanor. You were found guilty of class 1, class 2, or count 1, count 2, and count 4. So careless driving, driving under restraint, and no insurance provided by the driver. Given what we've had kind of a long day today, what I'm going to suggest is that we set this over for sentencing. I'm not going to request any sort of PSI in this case, given that they're traffic offenses. I believe it would be appropriate, but I'll set it over for sentencing. In a couple of weeks, we'll come back here for sentencing. Right, Ms. Real, you need to appear back in front of me in a couple of weeks for that sentencing. I'm going to explain something to you. I'm going to keep your bond in place. It's a $100 personal recognizance bond. You need to show up, okay? So you've come to other court cases and you've appeared, but we've had issues in the past, right? I had to issue an order 3 times for you to get your fingerprints done. And ultimately, I had to issue a warrant for your arrest in order to get your fingerprints done. I don't want to have to do that again, so I'm just pointing it out. I'm going to set this for sentencing in 2 weeks. I need you here in 2 weeks for sentencing, okay?
Your Honor, may I interrupt? I'm sorry.
You can.
I think a PSI would be appropriate in this case. Ms. Rael has a felony history. She served 8 years in the Department of Corrections on a case out of Denver, 2006. She has a significant criminal history. We were going to ask if she be remanded into custody today.
Well, had she been convicted of driving under the influence, I would have certainly considered it. But the fact that she's convicted of traffic offenses or infractions, there's no insurance, driving under restraint, I'm not going to remand her to custody today. I will tell you, I would have remanded you to custody, Ms. Real, today if you were convicted on driving.
Your Honor, I've already paid my dues for that case. I shouldn't have to pay them again.
Well, here's the thing, okay? So if there's that kind of history, I get to decide. Okay, now it's out of the jury's hands. Now it's in my hands. I'm the one that gets to decide what the appropriate punishment is for these violations. Okay, jury found you guilty of these. If there's a history there, then I think that does make some sense. I want to see that history. You may have paid the price that you have for those, but I can look at criminal history when I determine what the appropriate sentence is. Okay, so based on that information, then I will order a PSI done for Ms. Real. I'll set it, it's going to be set out longer. I'm not going to set it in 2 weeks. It's going to take longer than that to get a PSI. Okay. That means you have to report to probation, Ms. Real. All right.
Probation?
Yeah. So they can do a PSI with you. Probation is.
What's this PSI?
It's called a pre-sentence investigation report, Ms. Real. Okay. So here's what I'm going to do. I'm going to set this matter over for sentencing. And I'm going to set it in April, on April the 21st. We'll come back for sentencing at 11 o'clock, right? So April 21st at 11 a.m. I'm ordering Ms. Real, again, the bond will remain in place. It's a $100 PR bond at this point. You are ordered to report to probation in Alamosa at the Judicial Center, and so that you can do a pre-sentence investigation report so that I can have that prior to sentencing. Do you have any questions about that, Ms. Real?
I don't know where that is.
It's located in Alamosa. Do you know where the Justice Center is in Alamosa?
You mean the courthouse?
Courthouse?
Yeah.
It's right there at the courthouse. All you gotta do is go to the courthouse. Walk in, walk through security and say, I'm here to see probation about doing my pre-sentence investigation report. Probation will know that you're there. So check in with them, then they'll schedule a time for you to come back in and you can set that appointment, okay? You might be able to call them before you go first to see if you can set up an appointment. It might save you a trip, okay? So I'd reach out to them first. Might save you a trip down there. Right, that is an order of the court. Explain it to you again because we've had this issue in the past. Either you go, if you don't do that and I get report that you haven't showed up, I'll issue a warrant for your arrest. Is that clear, Ms. Real? Either you understand that or you don't, Ms. Real.
Well, I know what you're saying. You told me what I gotta do.
So that means you understand it?
I do not understand. I don't like that word.
Okay. Are you going to comply with the order that I just issued?
Well, we'll see.
No, we won't because there is a way for a judge to get you to comply with the court order. He can lock your dumbass up and force you to get your PSI done. And that's exactly what he does.
Okay, based on that, I'm going to go ahead and remand you to custody today. You're going to be going to custody today because I'm not going to play. I'm not going to play. No, not going to play around, Miss Real. There's no, stop. Your time. No, Miss Real. No, I'm not waiting a minute. Here's what's going to happen. I'm going to set $1,000 cash or surety bond, $100 bond. You're going to be remanded to custody. You bond out, you go to probation. If you don't, probation will contact you. This is what I'm talking about, Ms. Real. You come in here and you say, well, I don't understand. I'm not going to do this. I'm not going to do this. I just asked you. No, stop, Ms. Real. Stop.
Just the wording,
No,
Your Honor. Wait
I'm done.
a minute. It's
Nope.
the wording.
Nope, I'm
And
done.
you've committed treason in the
You can tell
case.
me I've treated treason.
You've done it twice already.
Nope, we're done. Ms. Real,
You've done it twice.
please take her into custody. Your bond is set at $1,000 cash or surety or $100 cash. You will comply with the court's orders because I'm not going to do this again.
No, that's not how this works, because a judge does have a way to make you comply with a court order. He can simply have you taken into custody and make sure your PSI gets completed. And that's exactly what ends up happening. And that, my friends, is what happens when poor decisions get in the way of your own freedom. Alright guys, that brings us to the end of the video. The first case has a jury trial coming up, and the second one is heading towards sentencing, so we'll have updates on both very soon. If you enjoyed the video, make sure to hit the like button. If not, you can hit dislike. But don't forget to drop a comment below and subscribe with notifications turned on so you don't miss any future content.